you. Sure. All right. Good afternoon and welcome to the Court of Appeals. We have one case for argument today. Your panel, I'm Judge Donna Stroud. To my right, we have Judge Wood. To my left, we have Judge Fred Gore. And we have our one case for argument today. I understand that y'all have, since you have cross appeals, you have decided how to divide up the time, so we appreciate that. And from what I'm told, one side was reserving 5 minutes for rebuttal, one reserving 7. And then beyond that, y'all are going to go back and forth, and you're going to divide your time up, and you're going to be keeping up with it. I mean, we'll just be keeping up with the overall time for each side, the 30 minutes for each side. And then you're going to be keeping up with how much of that you use and how you allocate or what you leave for your rebuttal. I mean, we're keeping up with the rebuttal and clock. But, is that right?
Sort of.
Okay, sort of. Okay.
My understanding, Your Honor, is that I'm going to present first as the appellant.
Okay.
Mr. Andrews is going to present next as both the appellee and his client's lawyer.
Okay.
After which I present as the appellee and rebuttal for our appeal.
Okay.
After which Mr. Andrews will have a rebuttal for his appeal.
Okay, well, that's less confusing than what I was told. So that's good.
We were confused.
Yeah, because I got lost somewhere in it when they were going back and forth. Okay, so good. All right. Well, as long as y'all understand it, at least, so we'll be good. Okay. All right. Well, then we are ready to proceed.
Thank you, Your Honor. May it please the court. My name is Vernon Sumwalt, and along with a colleague of mine, Mr. Stephen Hayes, we represent yet another colleague of ours, Mr. Emerson Thompson, in this appeal from the North Carolina Industrial Commission. Normally, I would reserve a couple minutes for rebuttal, but because of the little bit confusing order of arguments because both sides have appealed here, our rebuttal will be built into our appellee argument, which we'll do during the next round. And as the things weren't already confusing, we're getting ready to talk about workers' compensation. And there's a couple of us within the state that accuse the workers' compensation bar of speaking our own language. So I'll try my best not to do that. Emerson Thompson was a defense lawyer. He was one of our colleagues. He didn't do workers' compensation, but he worked for Cranfill, Sumner. He was an equity partner there. And some of his compensation, some of his income was contractual by nature, as virtue that he was an equity partner on a half a percentage of ownership of the firm. I think the quickest way for the court to dispose of...
Let me just ask you a quick question. You have a very voluminous record. Somewhere in there, it is possible I could have missed it, but I did not see a partnership agreement within the record. Is the partnership agreement within the record? And if it is, can you point me to it?
We left the partnership agreement itself out of the record. Mr. Barry Pinnell, who was the law firm's chief operating officer, testified about Mr. Thompson's ownership. Mr. Thompson testified about it, but out of professional courtesy, we left the partnership agreement out of the record because, as you might can guess, the record on appeal is public record, and there will be a lot of defense firms who would not be happy with me if I put that in the record. But the testimony from the chief operating officer of Cranfill Sumner is in the record.
And that is that your client is an equity partner with 1%.
A half of 1%.
Yes, a half of 1% interest.
Yes, ma'am.
Thank you.
And by virtue of that half % interest, he got $32,000 a year in passive income between 2009 and 2015. Now, at the same time, the Industrial Commission found that he was unable to work in any employment after February 2009 forward. So the question is, how does this passive income operate or affect his entitlement to workers' compensation? The Industrial Commission gave the other side an offset, which is a curious word because there's no statute that allows for an offset in the Workers' Compensation Act. And for those of you who haven't practiced workers' comp, you know, it is 100% statutory. There's a whole Chapter 97 of our general statutes that enable the Industrial Commission tell us what the law is, but there's a statute about credits in there, Section 9742, but that's not what the Industrial Commission hinged its decision on. It called it an offset, and it relied on a 1986 decision from our Supreme Court, Moretz, in saying that not only do you take Mr. Thompson's $2,500 average weekly wage gross earnings, multiply that by 2/3, and that's not what he gets in workers' comp. He's capped at a maximum compensation rate of $730. But where the commission, we would contend, made a mathematical mistake is they gave the credit against the $730. What it should have done is take the passive income, if it's even countable, from the gross earnings of $2,500, and when you subtract the $615 average that the $32,000 a year gives you, it gives you about $1,880-something. 2/3 of that is $1,200-something. That's still above the maximum compensation rate. So even with that offset, if it's applied that way, Mr. Thompson is still entitled to $730 between February 2009 and the end of 2015.
So would he have, let's say he had not had a back injury, he had not had a physical injury, and for whatever reason he was maybe but not able to work or whatever, would he have still received this half of 1%?
Yes, Your Honor, it's contractual.
Right.
Now,
okay.
It was the Mears case, that was my case, looked at a severance package that was contractual. It says, well, there's no double recovery there because you're getting workers' comp payments for disability and the other payments are contractual. He would have gotten that. And it's really no different if, let's say, for example, that you own rental property, right? And at the opening session of court one day, you run into Mr. Walters coming through the door and you get injured and you're out on workers' comp. There's nothing in Chapter 97 that gives the state of North Carolina a discount of what it pays out or is supposed to pay out statutorily based on the fact that you've got a passive income, that you've got investment income. And that's the contractual income that Mr. Thompson received. And they did it, basically to offset his cost of health insurance and things like that with the hope that he would get back. But in the meantime, he was having multiple back surgeries and it didn't end up like he had hoped. So that's, from a mathematical standpoint, even if you get that offset, it was taken from the wrong starting point. And if you give the Industrial Commission the benefit of the doubt and take it from the $2,500 that the law was on its side, then you still get the maximum compensation rate for those 6 years, and that's where we're coming from. But we don't think there's a yes or no.
We're a little different scenario where we have multiple appeals back and forth. What is your contention of the standard of review from the commission?
On this, it's a legal error. I don't think either party disputes what the facts are. It's just that when you're taking gross earnings, there's no statute on point that gives the commission the ability to give an offset about what is statutory prescribed. Now, there is a statute I mentioned earlier, Section 97-42, that gives a credit for alternative payments, but that doesn't apply in this case. And the commission says we're not going to cite it under that statute because those are benefits that are payable during a workers' compensation claim while it's denied. The other side here accepted Mr. Thompson's workers' compensation claim in 2008. They filed a Form 60 admission. And once they did that, it's an accepted claim, and they can't substitute the statutory responsibility for workers' comp payments with an alternative plan. If the commission looked at that statute, the only statute, this court, and even in Moretz, the only statute that gives them a credit is Section 97-42. There's no statute that mentions a quote-unquote offset. So if the statute doesn't give the commission the ability to do that, the commission can't create a new law, a new remedy, and discount what our legislature says, here's what you get in workers' comp.
Thank you.
I think that covers our appeal. We'll save our time for the appellee argument and the rebuttal argument.
All right.
Thank you.
Thank you.
May it please the court. My name is Neil Andrews with the Mecklenburg County Bar. Thank you. I'm here on behalf of the defendants. Sorry, it's a little nervous and a little cold out there walking over this morning. May it please the court. I'm here on behalf of the defendants, and I'm going to make and try and do the arguments as you've heard laid out earlier, both the appellee and the appellant kind of at the same time, and kind of going through the history of the case and discussing that issue. Your Honor, as you know, this is a 19-year-old case. It goes back a long way. In that window of time, there's been no indemnity checks paid by the carrier. No lost time payments in that window. Why is that? Well, in March of 06, Emerson had an event. In 07, he filed a Form 18. That's when he tells the state, hey, I've had a work-related injury. I filed that form. Defendants then file a form back, what's called a Form 60. That Form 60 is on your record on page 3, and that says what the carrier agreed to. And it's important in this case, because in that one they said on line 1, he injured his lower back. That's what they accepted. That's what they're liable for. Then on line 3, subsection D, it says, employer has continued full salary since the accident date. They notice the state. They notice Emerson. You're getting your salary. So no wages are being paid, no lost time, no indemnity, TTD, TPD. The lingo that my opposing counsel uses here that's unfamiliar to some people and that we forget about, okay? But they tell it, and there's no dispute that from 06 to 09, February of 09, he did his job as a trial attorney. There's no dispute on that issue. Line 4 of that record, it asks specifically, it says, disability commenced on this date at what rate? And it's left blank because the carrier never agreed to pay any disability benefits. And rightfully so, and no one's disputing it, because he's working and doing his job as a trial attorney at that time period. The question comes up, okay, unfortunately he has another surgery in February of 09, and at that time period, as Emerson testified to, it was entirely different. Changed him and affected him. At that time period, they continued, Cranfill, the employer, continued him full salary for another 3 months. This allowed him to go on to long-term disability, okay? But at the same time, Emerson and Cranfill, the firm, they agreed he'd become the client liaison person, okay? Business development, okay? Client retention. As Emerson testified at the hearing, okay, he said, I can sell a case the way Colonel Sanders sells chicken. That's why he's getting paid $32,000. Okay. There was a question that was asked to him.
Well, isn't he getting paid the $32,000 because he's an equity partner and it's a contractual obligation?
That's not what the full commission found. Okay. Number 2, that's not what was stated by Barry Pennell at the hearing. On his testimony on page 10, he said, we asked, if he didn't work, would he have gotten paid? And the answer was no. Likewise, in your exhibit package, this document exhibit page 4190 and 4191, there's emails between the Chad Hayes, okay, and Barry Simpson, okay, and in these emails, it says, we have an employee out on LTD right now. The group wants to pay, and this is in 2011, the group wants to pay this employee a nominal amount for business development, etc. He's a trial attorney partner, and the contract has specialty. Can you verify this would be allowable and not offset as LTD? Then right after that, it's from Barry Purnell to Paul Coble. This is dealing with the LTD stuff. And it's a voicemail recap from Barry saying, thanks for the voicemail. Just to be clear, we would like the option to pay Emerson outside of equity in the firm. So would you just pay him, so we would just pay him some nominal amount less than $50,000. Nominal is different to different people, I guess, okay? But $50,000 is not bad change. To assist with business development and other duties. Our wish is to remove his equity because our partnership agreement is pretty clear. Partners on LTD for this length of time should not be equitized. The commission's findings of fact were that they were taking care, that Cranfill was providing him, in finding of fact 18, I think, page 71 of the record, and conclusion of law 89 of the record. They go into that these payments to Emerson were a way for him to receive benefits. They didn't say this was like a stock. No, they said he's getting this because Cranfill is working with him to try and A, get some business, keep him active, keep him engaged, to develop some stuff because of his reputation and his skill set, and also to not affect what he's getting under the LTD plan. Now remember, it's important, there's a huge interplay between LTD, unemployment, okay, Social Security, disability, and work comp, okay? As you know, if the employer pays the premium, then they get the offset, they get the credit or the reduction, however we define it. We're lawyers, so we like to use specific terms, okay? But the full commission in its decision said offset or reduction in the decision. They didn't just use the offset, but they're basically saying this money being paid by Cranfill in that window counts. It either counts under 9729, 30, or 31, the statutes that deal with what type of benefit indemnity-wise an injured worker gets, or it counts under the case law that's come out from the court since 1986. But it counts in one of those manners. But it's not passive income. He engaged, he had an office, he had an assistant, he had cell phones, he had client meetings, he submitted expense reimbursements. That's what the evidence is in the particular case. And Emerson himself said in cross-examination at one point, you know, the question was posed to him, let me ask you this question so that I understand correctly. Was Cranfill giving you the money, whether at some points I've heard 24, sometimes I've heard 32, sometimes I've heard 64,000, whatever the amount was Cranfill giving it to you simply because you had a 5% interest or because you were generating business? You were Colonel Sanders, or was it given to you out of the goodness of their heart? How did it come about that you got that money? And his answer was, I don't know. I don't argue for it. I think it was originally started out because I'd taken a substantial pay cut from 256,000 down to 120,000, with Kim France at Unum claiming she was going to drop me another 120, drop the 120 to another 48. So Emerson's talking about here, it's the interplay between Cranfill, LTD, and that. He's not talking, I'm getting it because of the 1%, and that's not what the full commission found. This is a situation where we get up, and it happens often in work comp. A person wants to go back to work. A company wants them back to work. They go back to work, and then some point down the road, sometimes a year, sometimes a month, sometimes 6 years, sometimes 10, at some point, the guy goes, I can't do this work. Or someone says, this work isn't legitimate. You can't find this in a competitive marketplace. He didn't have to do this work. This takes us right to the Clayton case, Your Honors. In the Clayton case, what we deal with there is an accepted claim under work comp. TTD and TPD was paid. It's the closest one I can find that's kind of similar to Emerson Thompson's case. Okay, it's not exactly on point factually, but very similar. He goes back to work. They pay him temp partial benefits, meaning they give him some wage payments, and he's getting some wages from the employer, and because he's not making what he made pre-injury, he's getting some work comp payments. He's getting a little bit of both. That's the 9730 analysis you hear about on the math. That's he's making what he's working, but he's not making what he made pre-injury, so we give that variance. In the Clayton case, though, in the particular Clayton case, they accepted on a 60. They were paying disability benefits. He went back to work, okay, and then the court, the full commission, ultimately found the job he was in wasn't suitable. And if I remember correctly in that one, he was only working 4 hours a day. If they had work, he came in. If they didn't have work, he wouldn't come in. It wasn't a job that would be out there in the marketplace. We could have argued, and we did argue at the lower level about whether Emerson was in make work as a client liaison or not, okay? But as we sit here today, they found that this was a make work, the full commission, so that's where we sit. But in Clayton, they found he was in make work, and they said, the employer is not required to make duplicate payments of benefits when an injured worker cannot receive more than he is entitled to by the statute. I.e., the argument was, hey, wait, the wages paid by the employer shouldn't count, and the court said, no, you don't get both. He was being made whole during that window, and so you don't get to say no reduction, credit, offset, what term you want to use, you don't discount them. That's what the full commission did here. We asked you to form the full commission statement that this payment made by Cranfill from 06 to, from 09 to the end of 2015 is basically a payment under work comp, because what the court said is look at the basis by which they're making that payment. If it's a contractual benefit, as opposing counsel argues, like severance pay or accrued sick time, if it's something that you've got by your contract, then yeah, you don't get that reduction. But if it's being paid because of the work you're doing, or if it's being paid as a disability benefit because you're not getting a benefit through work comp, okay, then you do get that. You do calculate it into the equation. The mistake here, or the commentary for the second part, is the miscalculation. In 2006, when Emerson was injured, the thing he could get was if he went back to his regular job, he could get what's called a PPD payment, a permanent partial disability. If he couldn't work at all, he could get total disability for the rest of his life. That's $730 until the day he passes away. Or if he could work but not make his wages as before, he could get $97.29, that temp partial, the difference between pre- and post-injury wages. But there's a catch. You only get that under the statute for 300 weeks. It's limited. It's capped at almost just short of 6 years. If the full commission awarded Emerson temp partial benefits, said this was a real job, okay, I agree with opposing counsel that you do the math he uses. That's what the statute says under 9730. But he would only get it, and then it would end at week 300, and nothing further. Emerson has the right to elect the remedy that's best for him. That's total disability, potentially, if he can prove it. In 2018, we agreed. We didn't agree why he was disabled. We didn't agree the causation, because we did litigate the underlying issue of is the surgery in 2009 related or not. We lost it, that's fine. But it was in litigation, and it's important to go to when I get to the 10% penalty. But he's disabled, and under 9729, the only thing he can get is the 730, period. That's the most you can get. The statute 9729 and 06 and today says you can only get up to the max comp rate, which for his year was the 730. And if you try and calculate it using the temp partial, one, it's wrong because it's the wrong statute. But two, the payout would be the 614 plus the 730, which means Emerson would get $13,045 and some change, which is more than what 9729 allows by its plain language. Now, don't get me wrong. As it relates to Emerson, he makes out better long term, though, because he gets lifetime, the 730. So yes, for that window of time that he worked from 2009 to 2015, he only gets the 144 amount. But thereafter, he's getting the 730, and he gets it for the rest of his life. So we find and would argue that the full commission was correct and ask you to affirm as to the credit or reduction, the payment of finding that the 614 was a work comp benefit in essence, because it is the employer who's a defendant in the litigation paying for services, not contract, not passive. He had to do something and show up to get that benefit.
You said there was a finding on that was not challenged. So can you point me to where that is?
Where I made the note, Your Honor, for myself on that particular issue was finding of fact number 18, which was 71 on the record. There's no finding that this was passive income. And then on page 71, the actual specific quote was, from these payments, plaintiff's expenses, including costs for benefits from 2019 to December of 2015, plaintiff performed some client development, business development, client liaison duties, etc. for less than 30 hours per week. The nature of plaintiff's work was limited and was more of a way for him to receive benefits and defendant employer to retain clients and to continue to market new clients and maintain client goodwill. He received, it does say continued partial equity payments monthly during the time in the amount of 32. From these payments, expenses including costs, benefits, health insurance, and others were deductive. All right. Plaintiffs had phone conversations And then if you go to conclusion of law number, one second, conclusion, it's page 89 of the record, Your Honor. And it's the conclusion of law number 10. It deals with the Form 60. I'm looking. Yeah, conclusion of law on page 89 is what I've got. Amount some salary continuance, the very end of the 10, well, about halfway through it, it says, after the case site, it says, for the $615.38 per week paid to plaintiff in the amount to pay some amount of salary continuation and receive some compensation to continue plaintiff's access to benefits and offset the cost of them.
It says in the discretion of the full commission. Is that a discretionary determination
Yes, Your Honor.
under
The case law.
under the cases?
Yes, Your Honor. They could have denied that.
Okay.
And in the context of this claim, you know, the defendants were arguing to the full commission that he wasn't entitled to any benefits, that he's either not disabled at that window or that by the course of conduct here, he's stopped from it. They found those, you know, they found that they weren't in agreement with those arguments, but then did come and say, well, having looked at this course of conduct, it looks to us like the employer, the carrier, and the defendants were sitting here trying to go around to figure out a way that let him maximize his recovery, but at the same time limited the work comp payment, okay? And you can see that with the consent orders going for years here, okay? Trying to reach some sort of deal about how do we deal with this. Because if LTD gets the offset, then he would get the full $730 if they're taking their offset on their payment. There's different offsets. There's his wage offset, which no one knew about in that window of the consent agreements. You'll see in there that it talks about his equity payments stopped. The consent agreements that are in the record say his equity payments stopped in that window. If you look at I've got it as document exhibit 2667 through 2683. You know, the drafts, these are not binding. These are just the parties trying to reach a deal. At that time period, it says plaintiff returned to work for the employer defendant after 06 injury, but subsequently went out of work and stopped receiving his draw for payment as a partner on or about February 9th of 09. Now, this is a document drafted between the attorneys, but in that document, to this passive statement and also to the question of benefits, he stopped receiving his draw or payment as partner on or about February 9th of 09. The defendant employer then paid the deductible for his LTD, which was one of the things that gave us the argument before about we paid it so the LTD offset would come to us. They said, well, no, you know, that's an interesting question. Emerson's an owner of the partnership. Okay, so he's an owner. The employer's paying it, but it's also him as the employee in essence. So how do you deal with that? It's a question we asked the full commission. They said he paid it. That's fine. But as we sit here in this, it sits there and says the agreement between the parties never signed would be, which applied to his prior draw until his LTD began. Then the question is who got that offset that we never were able to deal with and were at issue as part of this litigation. Thank you. I get talking fast and it gets going sometimes. So for our side, the Clayton case and their prodigy all indicate that the full commission was correct on the 614. The math is you can only do 740. That's the only thing they can award is the 730, excuse me, on that. And to calculate it in any other manner would push you over that number. It gets you to the 10% penalty issue. I think the full commission made a mistake, an error in that concept. In the Clayton case and in the Rice case, in both of those, a form was filed in one a 60 and the other a 21, but agreements by the carrier to make indemnity payments, lost time payments. And then in both of those cases, they stopped the payments. And that's where an award comes in. There was an award, an agreement to make payment, the 60, the 21, and then a stoppage of payments, which is where the 10% penalty comes in on those, which is why the court said it's owed. The full commission, following those cases, would say, oh, in their logic, they said in the O&A, there was an award. The defendants filed a 60. The defendants in 2018 agreed Emerson was totally disabled. And so they're saying there's payment due and they didn't make it. So there's a 10% penalty. Our position to the court is under 9718E, there has to be an award. And in the context of this case, the Form 60, unlike Clayton and unlike Rice, there wasn't an agreement to pay indemnity. That Form 60 doesn't say that they're paying an indemnity by the carrier. And there was never a stoppage of checks because checks never started in his case. They become owed in this context when the full commission, and now ultimately when your decision comes out, says what the defendants have to pay. Then they're owed. Then the timeline starts for us to make the payment timely. But you can't get to subsection G, the 10% penalty, without going through E that requires that there be an award in that context. The full commission did say there was an award based upon the 60, and our position is you can read the 60, it doesn't say that. And in fact, there was no indemnity paid or stopped, so these cases are different.
So doesn't the Form 60 accepts liability, and therefore they're supposed to be payments? Isn't that correct?
Well, no, I would disagree, Your Honor, respectfully, and the statement, and that's part of the reason I started in 06, because from 06 to 09, no one thought that there should be any payments made to him. He's working, right? In fact, the plaintiff's attorney filed a 33 in that window in 07, said you owe me TTD, and then withdrew it saying, no, there's no outstanding issue. Same thing in 2012, there's a 33 filed for TTD, the lost time. At this point, Emerson's not working as a liaison. Oh no, he's still working as a liaison, excuse me, in the 2012 filing. And at that point in time, he again withdraws it. There's 3 years of emails back and forth about trying to get the consent order hammered out. And then they write the commission and say in his email that at this point in time, there is no outstanding issue. If the plaintiff and the defense attorney aren't sitting there saying that there's something owed and paid, okay, and don't need a hearing, I don't believe that the full commission should have said it was owed and paid based upon that course of conduct. Did I answer your question, Your Honor?
Yeah.
I hope I hit it. Okay, thank you. So we would contend that it was error to award a 10% penalty and ask that the commission be reversed on that part. I think there was a simple misapplication of the analysis under the Clayton and Rice aspects. This gets us to our kind of our biggest issue. Our biggest issue is 9725. Whether it's 06, 08, 2011, or now, there has been a constant clause in that statute that indicates that an employee refuses to accept any medical compensation when ordered by the commission shall bar the employee from further compensation until such refusal ceases, and at no time shall compensation be paid unless the refusal is justified. So the first half of that sentence is there an order that the employee violated? And it's stipulated in this particular case that he violated the commission order. You know, the original issue on home modification, he agreed he treated outside the work compact sometimes, okay? As it relates to the home modification, we have a stipulation 11, record on appeal page 16, that the defendants tendered the modification as ordered by the commission in its July 22nd, 2019 O&A. So the parties agree that there was an order for it. It's ordered under the decision from Deputy Commissioner Bruce that we tendered it in October and that he refused it. Now remember, the home modification litigation, there was 3 things. 1, does he get an addition to his house, or does he just get a first floor living setup made for him? That was the contention between the plaintiff and the defendants. And we were also trying to put in a chairlift and grab bars that he was refusing to have put in. In Deputy Commissioner Hollander's decision, he found that, in Deputy Commissioner Bruce's decision, the first one on home modification, he ordered the plaintiff to allow us to put in the grab bars and the chairlift. And the reason for all this is Emerson saying I'm constantly falling. I've injured myself numerous times from falling. I walk a certain way in order to keep my balance, and Emerson's talking about I fall almost once a week. He's saying 50 times in a year, okay? And the doctors say he needs to live on one level to prevent a fall. It takes a little bit of time to do a modification, and then if you don't agree upon the modification, you can't do it. Whether you say, yeah, we'll convert a living room into a full bedroom with en-temps bath on the first floor for you, and they say, no, I want an addition. If you don't agree, then the only remedy we have for both sides, and it's a good thing in this country, is a judicial remedy, okay? We went to court over that part of it in addition to these other points, and the court said, first floor living, first floor, that works. The defendants tendered. You can have this modification or that modification. You choose which part of the first floor is modified, or alternatively, if you want to go out and fix it in some way you like, we'll give you the cash equivalent to do that. Emerson refused, and at hearing, the reason he said he refused is, my wife owns the house. Okay, we're co-owners in that house. The co-ownership went back before the date of the hearing. Emerson's, as you heard, is a trial attorney, a sophisticated gentleman who knows it was co-ownered, and if his wife didn't want the house modified, he knew that when the case was tried.
No, I just want to make sure you know you're at a little over 3 minutes, but anyway, go ahead.
Thank you for warning.
Wasn't I was going to say, but isn't that just making a presumption that perhaps maybe he didn't know that for a fact? Because wasn't there also testimony that his doctor and the architect said that the addition wasn't going to work for his needs?
Okay, so we're going into two different things. One is the 9725 in terms of his refusal to take that order when he needs to be kept on one level is an unjustified refusal. The commission excused it. And then there's the second issue of what you're asking me about as to the specifics of, hey, is this modification necessary or appropriate in that context? But they said that the full commission the deputy commissioner, found that it was required. Okay, and then he didn't appeal it. Now, he testified that he didn't take it because it wasn't what he wanted. That's in the transcript. He wanted the addition. And number two, he didn't own the property. The refusal to take it is one under 9725. It's the refusal for the medical treatment to keep him safe. You know, if he falls down the stairs today, the defendants have to pay it. If he falls because of his work injury, because he's still going up them, the defendants have that exposure. We tender a house, we tender a first floor living space in the context of this, and he says, no, I'm going to defer it. I'm going to come back to that later was his actual testimony that we cited to in our brief. Okay. And our position is he can't do that. He has a duty to protect himself, to act for his own best welfare under the law, and that he can't sidestep that duty, and the commission shouldn't let him sidestep that duty. And that if he does do that and puts at an increased risk for the defendants, the remedy the law provides for under the statute under 9725 is the issue of saying you don't get any benefit in that window of noncompliance. He can cure it real easy by allowing the modification. That keeps him safe. That prevents liability towards the defendants. And it does the most important thing, which is make sure he doesn't have a fall downstairs, which is what everything's going on about with the doctors and so forth. We can argue about whether it was the addition or not, but that's been decided by Deputy Commissioner Bruce as to what was the appropriate remedy in this context of his case. But and when I said it was getting into 2 points, and I know I got 20 seconds, it's one, the noncompliance would stop TTD. The noncompliance would stop medical and indemnity. Okay? It says the refusal shall stop all benefits under the statute. He can easily cure it if he chooses. Hey, they can write me a letter tomorrow. Hey, get the contractor into the property. Boom. Issue solved. But you leave us out there with the risk with no remedy. The second half of that is the attorney's fee issue, to your point. The statement in his testimony, the evidence is the deed is 99. I think Emerson knew exactly what that deed was, who owned that house and did not know that owned that house. And he knew the situation when he tried the case then and now. And that is undue litigiousness. I mean, for you to know, I don't have the right necessarily to make a modification, but I'm going to ask for it. And then when you get it, but it's not what you want, you say, never mind. There was a lot of cost, expense, time, and energy for the commission, for defense counsel, for plaintiff's counsel, for court reporters and doctors that I guess it's okay. It's just, a defendant case. Thank you, Your Honors, for listening to me. I didn't get to one point, but I do appreciate your time.
All right, thank you.
So a lot of what my friend just told the court were the same arguments we heard at trial. What we didn't hear is what the standard of review is, because as the panel knows, this is an error-correcting court for what has already happened at trial. So let's talk about the housing modifications to start with. That was disposed of an opinion award in 2019. That opinion award was not appealed from. And as you just heard from my friend's argument here, after that opinion award, there are two options. Or you could settle the case, Mr. Thompson. Three options of what you can do with the housing modifications. There's no order specifically telling him this is what you got to do. It just opened the door for the different proposals to be made. So if he didn't like one versus the other two, he is not in contempt. He is not in violation of that order. And the opinion award that gave rise to this appeal determined that. And the full commission determined there is no undue litigiousness here on Mr. Thompson's part. That is the standard review because it's an abuse of discretion. Which begs the question, why should Mr. Thompson pay penalties, fees for unfounded litigiousness when the defendants argue he's not permanently and totally disabled after stipulating to permanent total disability a couple years before? When defendants could have initiated temporary total disability back in 2009, when it wasn't an attrition of his health from an injury, it was a failed back surgery syndrome. And we're dealing with, apart from Mr. Andrews' law firm, I don't know which one's bigger. We're dealing with Cranfill Sumner, who's one of the largest workers' comp defense firms in the state. How do you know that one of your equity partners is not disabled when he has failed back surgery syndrome? Because what they are asking to do is to penalize Mr. Thompson. Specifically between 2009 and 2015, I want to walk this dog down the road a little bit with the argument. Let's say that this activity that Mr. Thompson did during these 6 years was true work activity, like you've heard. First of all, that's not what the commission found. The commission found in Finding of Fact 18, page 71 of the record, the evidence does not support that Mr. Thompson regularly worked 30 hours per week or that Mr. Thompson was performing a job generally filled at an employer firm or other law firms. He's incapable of work of any work after that point. But let's say, for example, that Mr. Thompson did have some earning capacity. When that situation, Mr. Andrews will not disagree with me, we are operating under the temporary partial statute, which is section 97-30. And if you read that statute, it says you take the average weekly wages before the injury, the $2,500, and you deduct the average weekly wages after the injury, which is exactly what I was saying before, is you don't deduct that $615 average from the $730, because that would penalize Mr. Thompson. You deduct it from the $2,500. Whichever way you cut it, he gets $730 a week. What they are asking you to do is to penalize Mr. Thompson and not give him the full $730 when he has absolutely no wage earning capacity. So why should Mr. Thompson be worse off than someone who does have wage earning capacity and gets $730 a week? That is completely at odds with the purpose of the Workers' Comp Act. And we would disagree that the payments made during those years were not equity payments. If you look at Finding of Fact 18, it says he received continued partial equity payments monthly during the time, which amounted to approximately $32,000 a year. That is a finding of fact by the commission. It is supported by the testimony. Any competent evidence. I never heard those words coming from Mr. Andrews about. That is our standard of review for this issue. So, the refusal issue. You only heard my friend talk about section 97-25. We've argued this in our brief. That is not the statute that applies here. That is a general statute that deals with medical compensation. But if we rewind the clock to 2006, the year that Emerson Thompson was injured, The statute that governed was Section 9729 that says, in cases of permanent and total disability, medical treatment shall be provided for the lifetime of the injured worker. It's important to see what the statute says. Just read it to you. It's also important to see what the statute does not say. There is no provision for suspension in Section 9729. It is silent. And why is that? And we raise an analogous case dealing with Section 9732 at suitable employment, where there is a similar suspension of compensation for noncompliance there. And that's because the definition of medical compensation involves treatment that will, quote unquote, lessen the period of disability. You cannot lessen the period of permanent disability. It is permanent. There is no incentive, there is no deterrence to suspending compensation when you're already permanently and totally disabled. And they stipulated a permanent and total disability. They stipulated to it, only to try to get out of it this last round of litigation.
But now, you can't lessen the disability, but you can make it a lot worse. You can fall and break your hip or hit your head and have a brain injury. Or
You could, but there's not a, there's, the 2019 opinion rule only says that the housing modifications are medically necessary. It doesn't say this is the kind of housing modification. We've got, as you just heard, 3 options.
well, a sprint falls.
I'm sorry?
A sprint falls, right? The issue, the problem is falling.
Right, right. But, you know, he's going to be a fall risk. That's, you know, the attendant care was part of that. Now, you didn't hear any argument on the attendant care. Again.
But he falls down the stairs and hits his head.
Yeah, any competent evidence. I mean, you got a life care planner, you got the doctor saying, here's what you need attendant care. You know, we never heard about the standard review on that issue. But, yeah, he's a fall risk. He's had, what is it, 8 back surgeries now? I mean, it's a lot. That's a lot. You know, the 10% late penalty, I think, I mean, I can't read the commission's mind here, but just looking at the statute, you know, you had the 14 days after it becomes due. That's section 97-18G. You have 97-18E that says it's due 10 days after, you know, that point. So you got 24 days there. We're looking at, you know, the credit statute that again, doesn't apply when a claim is accepted. But it says the alternative benefits can be paid only when workers' comp is not due and payable, when there's not an acceptance of the claim. You know, it's the same language. It's a different neighboring statute, but it's the same language. So what we have to look here is when are the payments due? And there's a previous Form 60, as we've heard, which again begs the question, you're one of the largest, most sophisticated workers' compensation defense firms in the state. How do you know that Emerson Thompson is not disabled when he has a failed back surgery on February 9th, 2009? How do you not know this? Are you not talking to your insurance carrier? You defend hundreds of claims out there. How do you not know this as Emerson Thompson's employer? I think that's why the commission imposed a 10% penalty. Because during these years, Emerson Thompson didn't know how it would fit in with Social Security disability and long-term disability. You know, we hadn't heard the double recovery argument here, which is good because you know what? We have a federal statute and an ERISA, a federally protected long-term disability plan that says when you get these years of workers' compensation, guess what? It doesn't go to Emerson Thompson. It's going to go to other people. And unless it goes to reimburse the Social Security Administration, the federal taxpayers get stuck with that bill, which is the effect of giving them the discount between 2009 and 2015. That offset that, again, doesn't appear in any statute. Those calculations aren't really before the court. That's my job in the next 2 years, which is going to be really, really fun. But it's to figure out who gets reimbursed. The Social Security Administration gets reimbursed first. There's a federal offset statute. And then whatever the 80% average current earnings figure is, if there's any amount owed from the long-term disability company or any amount reimbursable to them, we've got to figure that out. That's after the primary, the first payor, the workers' compensation payor, has to pay, which they have yet to do. Were we unfound? Were we stubborn, litigious? So we prosecute this without good cause? We won benefits since 2009. That was not appealed. The amount is from 2009, 2015. We won that. We won medical compensation. We defeated a claim against suspension. of benefits. They are relying on a different statute. We say that's not a statute that applies. It's a more specific statute that was in place the year of Mr. Thompson's injury. Were we being overly litigious for that? Well, we certainly aren't going against a stipulation a couple years earlier that we agreed to, only to try to get out of it when we realized, wait a second, if Emerson Thompson is permanently and totally disabled, then we can't suspend compensation. And I'll leave it at that unless the panel has any questions. Thank you.
All right. Well, you had used all of your time. Yeah. I'm sorry, our little clock is, it only does one thing. Yeah, it just, all we have is the red and the yellow and the, right, yeah, so, but, well, thank you all very much for your arguments. And we will adjourn.
One day all this stuff will be One day this case will be It's going on for a while.